This is a video that is trying to show you how, or rather clarify what we've just covered in civil procedure this week. Subject matter, jurisdiction, constitutional congressional limits, and an intro to 1332. So these are the topics that I am trying to recap that seem to have the most confusion. The first is what is civil, or rather subject matter jurisdiction in the big picture. The second are key terms that people are having some issues with. And then the following two issues are big issues for a lot of people. How to deal with constitution versus congressional statutes, complete versus minimal diversity, and the last topic are a couple of issues in 1332. Okay, well, let's get started. So I try to create a jurisdiction flowchart. I know that you guys all have materials about what jurisdiction is, but I'm trying to show you in the grand scheme of things where we are in the semester. So basically we are starting with subject matter jurisdiction, the red, which is about which system we are in terms of courts, the federal system or the state system. After we figure out which system, then we'll move to personal jurisdiction, which is about which state in the system. And it says states because often there is more than one state. So after you figure out which system and which state, the next topic we'll talk about is something called venue, which is which district within a state. So for example, in the federal system in Illinois, if you know that you're going to be in federal court and in Illinois, you actually, under venue, have to decide which Illinois district, i.e. trial court, to start in. There are a number of trial courts, such as the Northern District of Illinois, which is in Chicago. There's also the Southern District of Illinois. So that's the big picture of where we are. So again, subject matter jurisdiction is not about which of the 50 states, it's just federal court or state court. Okay, so let's keep going. The next issue is about which terms mean what. So we defined these in class, but there are a lot of questions, so let me try to go over them. On the left are general categories. Limited versus general jurisdiction. What do these mean? So this is really referring to federal versus state courts. Federal courts are courts of limited jurisdiction in that they can't hear anything. The state system as a whole is supposed to be general jurisdiction. So in other words, in general, state courts can hear anything. That doesn't mean trial courts are courts of general jurisdiction, but if you add up all the different state courts, those are courts of general jurisdiction. And for this class, we are not focusing on state courts that only hear very limited things. We are focusing on state trial courts that hear most things. So our real focus is the limited jurisdiction of federal courts for the most part. Okay, so that's the first thing. Second category, concurrent versus exclusive jurisdiction. This again is about federal versus state. If a case could be heard in both federal and state court, that's a situation where there is concurrent subject matter jurisdiction, and it's up to the plaintiff to decide where to file. There could be exclusive jurisdiction. We've talked about when, in some cases, there's exclusive federal jurisdiction. You don't have to memorize all of these, but you might remember we talked about in class bankruptcy cases have exclusive jurisdiction because the statute says so. Next week we'll talk about some situations that, although there's not a statute, actually by common law interpretation they end up having to be exclusively heard in state court. But in general, concurrent means that both state and federal courts can hear, and exclusive means it can only be in one system. Now the last set of clarification terms has to do with original versus appellate jurisdiction. Original jurisdiction, when you see it in a statute or the Constitution, is generally about trial courts. Who is the original court to hear the first case? Appellate jurisdiction means there was a trial, someone lost and now they're trying to appeal to have a higher court decide whether the first trial court got something wrong. So those are all the general categories. If you're having trouble remembering these terms, you might want to try to come up with your own glossary and or maybe create your own index cards to test your understanding of what each of these terms means, because you will need to be familiar with what they mean. Now, moving over to the right-hand side in terms of questions, one question I had was, what does concurrent SMJ have to do with original? Well, what they have to do with is, remember, original has to do with trial courts. So at the trial court level, as a plaintiff, you want to know if this is a situation where both state and federal courts have concurrent, such that you get a choice. That's what that means. The other question I got is, why would you ever say original jurisdiction if it's not exclusive? And the reason is, original jurisdiction is just about trial courts. So you don't always say exclusive, because sometimes federal trial courts do not have exclusive jurisdiction. It's only a small subset of cases that have federal jurisdiction that are exclusive. And generally those cases have a federal statute, which the magic word exclusive in them. Okay, so hopefully that helps clarify terms. So let's keep going. Next big issue is Constitution versus Congress. I know this is a big, big issue of concern. So there's really three sources of law that you have to know, and also how to integrate. There's the Constitution, congressional statutes. Two we've looked at a little bit, 1331 and 1332. If you feel like 1331 is fuzzy, that is absolutely fine. I only introduced 1331 to show you the different language versus 1334 for exclusive. We will be dealing more with 1331 after next week. The last source of law, cases, is really important, because when there's a Supreme Court case interpreting either the Constitution or a congressional statute, that becomes part of the law. So it's not in the statute or the Constitution, but you just have to know from the cases that that's part of it. And that's what you have to have in your notes and eventually your materials preparing you for the exam. So, big picture questions on the right side. The first is, does the Constitution or congressional statute provide SMJ? The answer is both. The Constitution provides Congress with the authority to give federal courts, to create federal courts, to hear cases. It also gives the Supreme Court subject matter jurisdiction. But the Constitution does not actually give lower federal courts any subject matter jurisdiction, because it doesn't create any. So for that, you have to go to the congressional statute. So when do you evaluate whether something is constitutional? When do you evaluate, for example, if 1332 is constitutional? In general, you only evaluate it if I ask you. Or in real life, you evaluate it if someone is challenging whether the congressional statute is constitutional. The reason we're focusing a lot on the Constitution is because it's important for you to know that although there are some laws like 1332 we use a lot, Congress can and does always create new laws, and you need to understand when it's constitutional or not. But in general, in reading cases and understanding 1332, you don't always go back to the Constitution, although you should understand whether or not it is constitutional. Okay, so here are some more questions that I've had. So the first is, where does it say Congress can make laws? So not in general, but for federal courts, it's actually in the Constitution, Article 3, Section 1. The first sentence says judicial power is in the Supreme Court and in inferior, i.e. trial courts, as Congress may from time to time ordain. So that's saying that the Constitution is giving Congress permission to create. It doesn't say create in those words, but that is what it's doing. The second question I hear is, why doesn't the Constitution overrule congressional law? And again, it might help to look at the Constitution. So Section 1 just says that there is judicial power in one Supreme Court and maybe lower inferior courts. And then Section 2 says what the judicial power will include. It gives all the categories. But neither Section 2 nor Section 1 really tells you what federal courts can hear. So there is nothing for the Constitution to overrule, because the Constitution doesn't really say federal courts can hear certain cases. It doesn't give them any power, so there is no overruling. It's true that there's a supremacy clause, and when the Constitution governs the exact same thing, gives the exact same power, it would overrule, but not always, if that doesn't apply. So the next question is, do you always follow the Constitution but not the congressional statute? And the answer to that is, well, go back and look at the Constitution. In some cases, the Constitution doesn't give you any authority. So it's not a matter of following the Constitution versus the statute. If the Constitution doesn't give you any relevant guidance to what federal courts may hear, then you need to look for a different source, which would be the congressional statutes. The last question is, do the congressional statutes, like 1332, change the Constitution? And the answer is no, because the Supremacy Clause, they can't overrule the Constitution, but you should think of it more as filling in gaps that the Constitution doesn't articulate. So going back here, remember that nothing here actually gives federal courts power to hear cases, that is, lower federal courts. This is only about judicial power in the Supreme Court and what federal courts might hear if Congress establishes. But because Congress hasn't established it yet, we don't know if it'll be exactly what's in Section 2 or some subset, which is in fact what Congress has ended up doing. For example, in 1332, they did some subset. So if you remember in Section 2, it actually talks about cases between citizens of different states, but as you know, when Congress enacted 1332, they went much narrower and did citizens of different states with an amount in controversy. So it's really important to look at the Congressional Act, because that actually gives you the scope of what federal courts can hear. Now, one last thing about Article 3, Section 2, based on a question I had, which is, how do you get 9 categories? Well, you get 9 categories, not 10, because the 9 categories are the things with the bullets. The thing at the top, judicial power, that is the overall category that all of the other ones fall under. Okay, so there are 9 different categories of judicial power that apply to what the Supreme Court and any lower federal courts can hear. Okay, so this is the absolute limit, but this is not necessarily what federal courts can hear, because this doesn't give federal courts any power. For that, we have to wait until the congressional statutes, which we will get to shortly. Okay. Now, complete versus minimal diversity. The things on the right are all different examples, which we'll talk about in a second. But first, a couple of issues. Now, what's really confusing often is that there's the same language in the Constitution in 1332, citizens of different states. But the U.S. Supreme Court has said that the same language means different things in different contexts. So, complete diversity is what applies to 1332. This is what the confusing Strawbridge case says. You don't have to go back and reread it, but you should know that Strawbridge says 1332 requires complete diversity. This only applies to 1332. It does not apply to other cases. Minimal diversity is what the Supreme Court says is what the U.S. Constitution requires. That was stated in the Tashire case. You never have to cite that, but if you want to go back and find it in your casebook, that's what that case said. Now, some people were wondering, why wouldn't you use a congressional statute with minimal diversity, such as the Interpleader Act? Why would you use the harder complete diversity? Now, the reason is because the Interpleader Act has actually a lot of other requirements that you may not be able to meet. And that's why you might use complete diversity instead. So we've talked about complete, which is required by 1332, but not necessarily other congressional statutes, as in the Interpleader Act, whereas minimal diversity is all the Constitution requires in terms of what a federal court can hear in non-1332 cases and also the Supreme Court. Now, what is complete diversity? So the first scenario on the right, that is the Strawbridge case, and that fails complete diversity because there is a Massachusetts plaintiff on both the left and the right. This is an example of minimal diversity, not permitted by 1332, but permitted by the Constitution and some congressional acts besides 1332. So the bottom two examples are examples of complete diversity where there is no plaintiff with the same citizenship as a defendant. Okay, so moving on to 1332. Can a court decline to hear a case that meets the requirements of 1332? Well, let's look at the language on the right. It says district courts shall have original jurisdiction in certain cases. You should read this to say district courts must hear cases with these requirements. The court cannot decline. So this is directed at district courts. That's the who. The plaintiff, however, has the right in this case to decide whether to file in federal or state court because it's concurrent. Also, just as a reminder, the blue part, citizens of different state, under Strawbridge, we now know means those citizens have to be complete diversity in terms of plaintiffs, defendants. One issue that people find really confusing is what happens with U.S. citizens living abroad. Now, there are two important categories. People who are temporarily abroad, for example, if they're in an abroad program, or maybe they're on Peace Corps, they're only there for a limited time, versus someone who is domiciled. If you're domiciled, that means you're not only living there, you intend to remain there indefinitely. So, for example, you got married to someone in Australia, you bought a house, you intend to live there forever, even though you haven't given up your U.S. citizen. The one category that is really confusing under 1332 and doesn't fall under it is U.S. citizens living abroad that are domiciled abroad. Those don't fit because under Moss v. Perry, we know that a U.S. citizen's domicile only applies if they are living in a U.S. state and domiciled there. So those citizens who are domiciled abroad, they could still sue, but only under a different federal pathway than 1332, for example, 1331, which we haven't talked about, or they could always sue in state court, because those are courts of general jurisdiction. Okay? So the last issue of 1332 is B. So one question in your study guide is, what does this provision do? Is this a different type of SMJ, or does it take it away? The short answer is this has nothing to do with removing subject matter jurisdiction. This is about if you have a case that falls under 1332 and it went all the way to trial and the plaintiff won but recovered less than the amount in controversy, they might have to not get costs. That's all it's saying. So basically this is talking about the Mr. Moss case, right? So he won, but he got less than the jurisdictional amount. So he might have some issue with costs, but that doesn't deprive the case of subject matter jurisdiction. Now, B only applies to situations in A. So in other words, it only applies to cases under 1332. It does not apply to cases under 1331. Okay? Last final thoughts. So, can a case be heard in federal court? If you are asked this, what do you look at? Do you always start with the Constitution or the Congressional statute or both? Generally, you only look at the Congressional statute. Is there a Congressional statute that gives you permission? Why don't you start with the Constitution? Because the Constitution doesn't ever talk about what cases can be heard in lower federal courts, right? Because it doesn't create those. So in general, if you're looking as a plaintiff, where can your case be filed? You're going straight to the Congressional statute. Sorry about that. Second question. So if I'm saying you start with the Congressional statute if you're a plaintiff, when would you ever look at the Constitution? Well, the short answer is if I ask you if it's constitutionally permissible, for example, in a clicker question. The other way you would look at it is if there's a case and the case challenges whether a constitution, or what, sorry, if there's a case that challenges whether the congressional provision is constitutional. So basically, unless it's specifically raised in a case or by me, you don't go back to the Constitution, but that doesn't mean that you shouldn't know what those terms in the Constitution, Article 3 means. Last issue, congressional statutes, are they equivalent? Short answer is yes. Everything under 28 U.S.C., and in particular 1332 and 1331, are equivalent. And for our purposes, think of them as equivalent highways into getting into federal trial court. So next week we will talk more about the 1332 highway in terms of if you have an entity, and do a little recap on citizenships. The following week, we will talk about the 1331 highway. If you're confused or a little fuzzy on what 1331 means right now, that's absolutely fine. We haven't gotten back to it yet. So those are some general issues that hopefully are a little clearer now. If you have questions, feel free to ask, but I hope this helps. Thanks.